Hello everyone, I am Akshay Date from Corporate Law Journal. Welcome you all to this channel. As you all know, the purpose of this initiative is to explore corporate literacy and to impart corporate legal education in simple and lucid manner. In today's session, we will understand the probe on abuse of dominant position in marketplace by e-commerce sites like Flipkart and for the reasoning behind why Flipkart approached Supreme Court. Before jumping to the session, please subscribe to the channel and press the bell icon for more updates on corporate and commercial law. Before jumping to the main certain topic, let us first have a quick understanding on Flipkart business model and development in a sense of earning. We we all are in a world of technology and an increase of online commercial usage. Mostly everyone here understands that Flipkart is an e-commerce site company or a platform like Myntra, Snapdeal and Amazon. Flipkart is a giant holding company pointing over 160 million users and members and carrying over more than 150 million types of products in category. Now let us focus on the business model of Flipkart and the operating system of Flipkart. Flipkart mainly operates on the model of B2B, which is business to business. Here, Flipkart works as a platform of marketplace to hold goods and services. We can say it's likely work as market to market. Its system operation operating in a manner of market to market, business to business. It is a platform works on the fundamental of advertisement and market selling. Companies like Flipkart follows rules and regulation which are invested by the government, pointing FDI and CCI. Please note that Flipkart cannot issue or work on the model of B2C, which is business to consumers, likely to sell their own products and investments directly. Flipkart, if Flipkart has to work on the model of B2C, Flipkart has to segregate the model and Flipkart has to segregate the model using before, which is B2B, and segregate the model and continue with B2C. And if not, it's illegal in nature. Now, coming to the objectives and internal process and provisions laid down by the Competition Commission of India, which is very relevant for this session. In clear-cut manner, the most prominent factor or objective is to give freedom of trade and to reduce unfair trade in the marketplace. CCI focuses to bring fair competition and looks into anti-competition practices, which brings in any kind of abuse of dominant position by any player in a market. Here, the main objective is to get abuse of dominant position into light. Section 4 of Competition Act 2002 talks about abuse of dominant position in marketplace. It is so obvious in nature that to obtain dominance to a party, it should have a strong enough operating system. It should be strong in nature. It should be strong enough in nature. It should be independent in nature and it should be clear in the senses. And it should affect the other players in the marketplace. Please note that I have compiled the clauses in a very short manner in my presentation. Okay, now to obtain and to require the requirements for the ordering or stating the dominant position in the marketplace by a player, the following conditions should be fulfilled or included. Okay, so now firstly it should imposing of unfair conditions are must required. Firstly, on pointing out pricing or sales. Secondly, formulating barriers for other players. Thirdly, applying dissimilar conditions to similar transaction. Please note this and keep this in mind that dominance itself it's not prohibited. It's abuses, pointing out the relevant marketing. Okay, let us now understand with a case law. Blair's Owners Association versus DIF. Here, DIF imposed several clauses in buyer's agreement and action of cancelling allotations and deposits, and kept the buyer in a dark shape. Therein, court declared that there is a abuse of power and pointing unfair practices on transactions. Now we are clear with the provision section 4 of Competition Act 2002. Now moving on to the main concern topic for today, pointing on probe by CCI on Flipkart and why Flipkart moved and approached Supreme Court. It all started when All India Online Vendor Association has made allegations on Flipkart, pointing the abuse of dominant position as a player in the market. But CCI on November 6, 2018 given clearance to Flipkart. CCI given a clear chit to Flipkart, after which it has noted and found that after this order, CCI issued a market study covering e-commerce companies, e-commerce sites like Flipkart and Amazon, that there is an abuse of power in a sense, and there are unfair practices are still going on. The crossing conditions and approaches by the CCI in pointing the order and issued market study, which also continued with different allegations were with the variety of allegations were made by Vendor Association, All India Vendor Association, pointing the order, the market study, and the allegations by All India Vendor Association. Now we can say that this was the reasoning behind NCLT to order a probe against Flipkart. NCLT ordered to CCI to probe into Flipkart for abuse of dominant position. On March 2020, holding a strong order against Flipkart. Please note that All India Vendor Association also filed a caveat in Supreme Court, approaching Supreme Court for filing a caveat. Here the term caveat basically means a order or a issue of a particular authority for authorizing a particular party to indulge in a particular case. Now, if you list your eyes on various cases pending on Flipkart or orders, you will find that there were several cases on bankruptcy, breach of contract, and likely to this. So Flipkart, looking all this continuous flow of allegations and regarding this breach of contract, bankruptcy cases, and continuous flow of allegations, on March 2020, Flipkart, looking into all the probe and all, put allegations on order passed by NCLT to probe Flipkart by CCI, okay, which accordingly registered on July 17, 2020. And the case is still pending in the Supreme Court of India. That will be all for today, and don't forget to like, share and subscribe to the channel for more weekly updates on corporate and commercial law.